Hello everyone, this is the West Coast Inventor, most recently the inventor of the cam clip, which is going to be coming very soon. But first I would like to get to patents. What is a patent? How many types are there? What are the different categories? Basically, a patent is what you file if you have an idea for something. It's IP, intellectual properties, it does something, it functions, versus a trademark. So within a patent, there are three types, and there's always been three. There's a utility patent, which means it teaches you a new process, it has a new technology, it teaches you something, it shows you something, it turns on and off. There's at least one function, it does something. That's a utility patent. Then there's the design patents, which is often called the picture patent. It's an ornamental patent. What does something look like? If you see a car driving down the road without looking at the hood ornament with an emblem, any letters or numbers on the back of the vehicle, you know exactly what vehicle that is by the general look and design and feel of what that vehicle looks like. That's a design patent. If you laid out 5 cell phones on the table, everyone would be able to tell which one is which because every phone has its own look, its own design, and that's a design patent, much like cell phone covers. If you have an idea for a cell phone case, it doesn't turn on, it doesn't turn off, it doesn't function, it doesn't fly, it doesn't actually do anything. It's a one-off protective accessory for a phone. So you just buy your phone and insert it into the phone case, and that's it. So that would be a design patent. All cell phone cases are pretty much design patents. And the third category, the third type of a patent, is a plant patent. Anything to do with the horticulture industry, not something that was genetically modified or built in a lab somewhere in someone's basement. It's something in the horticulture industry. Plants, it's what it sounds like. It could be trees, shrubs, anything. So those are 3 types: utility, design, and plant. Now, inside of the utility patent, when you file a utility patent, it is called a non-provisional, which means it has one function and includes your text, a description. Be very detailed. Don't try to use too much legal jargon. Just be descriptive. Your claims, what does it do? Each claim has its own individual functionality. Those are your claims. Then you have your abstracts. Then you have prior art. Is there something that kind of looks and sounds like what you're talking about? You would include that, which that will come up in an exhaustive search. First thing you do is file an exhaustive search. An exhaustive search will roughly cost between $1,000 and $1,200 for a company or a firm to do an exhaustive search to make sure that there isn't something very similar or exactly like what you're talking about filed on record in the USPTO. Just because you don't see it on Amazon or Best Buy or your favorite TikTok shopping channel doesn't mean it doesn't exist and someone didn't come up with the idea. So exhaustive search is where you start, and 3, 4, 5, 6 weeks when it comes back, you will know if there's prior art, or those all need to be included in your non-provisional patent application. And of course, it will be examined by a patent examiner and then also a artwork examiner to make sure that your wireframe art supports the claims that is inside the patent, supports the IP, supports the functionality, supports what is the essence of your patent. And then the patent examiner, the main executioner, he will execute your patent and he will go through it front to back, top to bottom, left and right, inside and out to make sure that your patent is patentable, that it's not too much like someone else's, which would be a glaring similarity. It's very obvious that your patent is too close to someone else's. Just be sure that your patent application, your non-provisional patent application, isn't already out there and that it's not someone else's idea that you just changed. I'm going to move the power button over 4 inches. I'm going to change the colors of the protective casing. It's not original. That's not enough differentiation. That is not enough for your patent to be approved. That's a non-provisional utility patent. But also within the utility patent, there is another category, there's another application, and it's not a patent application because it's not going to be considered to be issued as a patent. In the fourth category, which is not really a category, it falls within the utility patent. It's not the non-provisional patent, which is your actual patent that you're hoping will be approved by the USPTO and issued to you as a patent. You have a patent number, is the provisional. The non-provisional is the patent. A provisional is when you have an idea, you haven't quite figured it out, you don't have the funds to hire a patent attorney, you do not have the funds to hire an engineer, and you haven't quite figured all the R&D and all the IP out. But you would like to make sure you have it on record, because when it comes to inventing, it's not first to think, it's first to file. Whoever is on record, whoever filed first, whether it's a day before, a month, a week, and a year, whoever files first, that's all that matters. So a provisional is just, hey, I have this idea. I don't have it all figured out yet, but I want to protect it. It's just planting your flag in the sand. It's just protecting your idea. So you file a provisional application. It's not a patent. Most people will say it's a provisional patent. No, it's just an application. You can go to the USPTO website. You can do this yourself. I recently did this a while back. I've done them before. Anyone can do this. Go to the USPTO website and you just file your provisional. So after you file the provisional application, the USPTO will immediately send you confirmation email. They will send you your filing number, the date, everything will be there on the page. Definitely save it. Get your phone out, take a picture of it. Make sure you save that. But then, of course, the federal government. So they will send you an actual letter, snail mail. They will send you a paper letter in the mail just confirming that you filed the provisional. And it's just planting your flag in the sand. Once again, it's just, I have this idea and I don't want somebody to file before I do. So you have your provisional application filed. Great, awesome, it's your idea. Nobody can take it. You're the first one on record, hopefully. Now the provisional isn't going to be viewed by anyone. It's not viewed by the public. It's not published. It's very, very private, very, very secure. In fact, not one individual with the USPTO, not one employee is going to even know that you filed it. They're not going to look at it. They don't go through provisional applications. They don't do anything like that at all. Only if you're challenged, then you can pull that out. It is on record. But you have a year, 12 calendar months upon filing your provisional that's received and you received all your letter and confirmation email. You have a year. So you have 12 months to then convert the provisional, the non-formal, it's on record, to convert that provisional application to an actual non-provisional patent application. And that, of course, would require patent attorneys, and you need your artwork, and you need everything, and put it all together and file. Have a utility patent, you have a design patent, you have a plant patent, and inside the utility, non-provisional patent application is the actual patent that you file. But built into that, it's not really a fourth category, but built into that is the provisional. So always start with the provisional. It only costs you, a couple of $300. You can do it yourself. It only takes but, a couple of 3 hours. Take your time with it. Put in as much as you can. It's not really required, but the more you put in, the more protected you will be. My provisional application looks and reads and feels and appears like a non-provisional, because you want to put everything you have into that, and you want to protect it, and you want to put as much detail into it, and you want to put your artwork into it. You really put everything you have into it. And here's the big thing. You'll save a lot of time and money, because when you go back to convert that provisional application to a non-provisional utility patent application, you're going to have to go to a law firm that specializes in patent laws. It has a patent attorney. Pick a patent attorney that is also a patent examiner. I'll get to that in another video for another day. Very important. but make sure you go to the right firm. And when they file it, because your provisional application, it's so well written and you have all of the artwork and here's your abstract and here's your claims and here's your prior art because you did an exhaustive search. Everything is so well written and drafted and put together. Your attorney doesn't have to spend that much time rewriting your entire patent application. Your patent attorney will say, wow, you really put a lot into this. Everything's here. I just have to make some adjustments, add some things, do my lawyer thing, throw in some jargon, do some of this, do some of that, mix it all together, draft it, and then he or she will file it. Because remember, attorneys charge by the hour. They're billable attorneys. So they're going to charge you quite a bit, especially patent attorneys. It'll cost you thousands of dollars to go through this process, which I most certainly am very familiar with that. Remember, patent attorneys, they charge what they're worth. And if you're inventing something or creating something, it's very unique and has some value. Do not cut corners. Do not try to do a lot of the difficult stuff yourself. Do what you can, but let he or she take the reins and just hand the baton to them as you round the corner and let them finish out the race. Let them run down the straightaway and get you across the finish line. And you will get your money's worth. But they are billable attorneys, so they charge you by the hour. It adds up very quickly, and I've paid quite a bit in attorney fees over the years, but you get what you pay for. So those are your three categories. Those are your three types of patents. So good luck inventing. I hope this was very helpful and educational for you. If you need anything, email me at inventor@cammclip.com. inventor@cammclip.com. Camclip. Look for it soon. Thank you so much and keep inventing.